So let's get to our other top story. In an extraordinary concession in court yesterday, prosecutors in the federal case against former FBI Director James Comey admitted the final indictment against him was never presented to the full grand jury. Interim U.S. Attorney Lindsay Halligan, who has had no prior prosecutorial experience, initially presented a 3-count indictment. But the jury rejected one of those counts, Justice Department lawyers said yesterday. Then, rather than drafting and presenting a new 2-count indictment, Halligan printed a new version without presenting it, and admitted only the foreperson and another grand juror were present for the signing. The judge appeared skeptical of the government's arguments throughout the hearing and went on to question prosecutors on whether the indictment was retaliation by President Trump. The judge also questioned Halligan, calling her a possible puppet for the president. Comey's attorney went on to argue the judge should throw out the case entirely, saying Trump used the DOJ to, quote, punish a perceived political enemy. Comey faces obstruction and false statement charges stemming from the testimony he gave to Congress in 2020 about leaks at the FBI. His trial is set for January. He has pleaded not guilty and is challenging the indictment on multiple grounds, including whether Halligan was lawfully appointed. And Lisa Rubin, I think, or Joe, I think that's a good question this morning.
Well, it certainly is. But that while we have wonderful, wonderful writers summing things up, that doesn't begin to scratch the surface of what sounded like, from our reading of it, one of the most extraordinary things to ever unfold in a federal court between a judge and a federal prosecutor admitting just an egregious mistake and then getting her assistant to stand up and the judge just eviscerating him. The guy, it sounded like the guy was shaking when he said, was there a memo written that said you shouldn't bring these charges? And he stumbled around. The judge went in again. I mean, he was like, make him stand up and sit down. And he was shocked. People in the courtroom were shocked. Again, begin to explain, because I've been trying to explain, D'Amica, how this never happens. I've never heard anything like this happening before at this level.
The story of the Comey indictment from start to finish is so riddled with irregularities, Joe, that we don't have the time in this segment for me to cover them all. The one that you just referred to was the exchange between a prosecutor that Lindsay Halligan brought in from North Carolina and the judge asking about the existence of something that Ken has reported on, a declination memo, which is what it sounds like. It's the memo that somebody writes when they are trying to advise a U.S. attorney, this case is not in the interest of justice, it shouldn't be brought. And that assistant U.S. attorney yesterday did not want to acknowledge the existence of a declination memo and tried to say...
Did he really think the judge was going to stop? I mean, the judge kept plowing forward. And again, every recounting of this said it was cringeworthy. The whole 90-minute hearing made everybody deeply uncomfortable because the prosecution was so incompetent.
It's not just that the lawyers were incompetent. I actually think that the lawyers who have been brought into this case from the Eastern District of North Carolina are probably decent prosecutors. It's what they were handed. It's the bag of, let's call it bandini, that they were handed to deal with and to have to defend. And so from start to finish, from dealing with the existence of the declination memo to the real shocking revelation of how the grand jury came up with this 2-count indictment, the whole thing had people's mouths agape. And I just want to underscore why what happened yesterday is so procedurally and constitutionally defective. This grand jury was shown a 3-count indictment by Lindsay Halligan, who by all accounts, including her own, was the sole prosecutor in the room. When she left the room at 4:28 to leave the grand jury to deliberate, about 2 hours later, they returned it saying, we're okay with 2 of these counts, but we're not okay with the 3rd. That's when, according to lots of case law, you're supposed to start over and make sure that every member of the grand jury has an opportunity to see the charges before them and vote on what that charging instrument should look like. And instead, according to a footnote in a brief that they returned last night, they had a deputy criminal chief consult with a grand jury coordinator and basically do a cut and paste job where they produced a new charging document with just the 2 counts the grand jury liked. And then instead of presenting it to the full grand jury, they just sort of rushed in to a magistrate judge, presented it with the foreperson and the deputy foreperson and Lindsay Halligan there. But Lindsay Halligan herself was so confused about what had happened that if you read the transcript of that exchange that night, the night that Jim Comey was indicted, the magistrate judge says to her, Ms. Halligan, I have 2 charging documents before me. One has 3 counts, one has 2 counts, and your signature's on both. Can you explain to me what happened? And she can't even represent with a straight face that her signature's on both. Oh, did I sign them both?
Yeah.
Oh, my signature's on both?
Unbelievable.
So Ken Delaney, the assistant lawyer that we're talking about here, Tyler Lemons, asked under all this questioning by the judge, eventually did concede, yes, there was a draft memo written by the previous prosecution team that said, there's no case here. We should not bring charges. So now that's on the record in the courtroom that happened. But a lot of people are asking, to Lisa's point, if not Lindsay Halligan, who has no experience as a prosecutor, was there no one on that team? Was there no lawyer who said, actually, this is how you have to present these findings to the grand jury? This is how this works. Like, how could this even have happened?
No one in the Eastern District of Virginia, as far as we can tell, Willie, every career prosecutor in that office, to a man and a woman, declined to participate in presenting that indictment to the grand jury, which is why Lindsay Halligan, a former insurance lawyer with no experience, had to go in there. And while these prosecutors from North Carolina may be competent and experienced, she obviously is not. And when the judge heard yesterday that this had happened, that the grand jury had not seen the actual indictment, there was a long period of silence in the courtroom. People were stunned. No one has ever heard of anything like this happening before. But as Lisa explained it, to me, it's an important violation, but it's a technical violation. The grand jury did vote to indict on those 2 counts. What I think is more consequential as a substantive matter is all the things the judge has been saying, suggesting that this very well could be a vindictive prosecution, if ever there was one. And Michael Dreeben, the lawyer representing Comey, who is the Deputy Solicitor General, it's interesting that he was there, was essentially beseeching the judge yesterday, put this to an end, send a message to this Justice
wasn't
Department.
That the purpose of this hearing? The overall purpose of this hearing was to see if it was in fact a vindictive prosecution because of the president's Truth Social posts demanding that his political enemy be taken down.
That's right. And a lot of people who are looking at this believe that this judge may well toss this case on those grounds. But why is Dreeben there? Dreeben is there because he's the Deputy Solicitor General, and he knows that this is going to be appealed, whatever happens. And so he's there for the long haul because there's important legal issues in this case that have to be argued in higher courts, and he's an expert in that. And so that was really interesting.
So really quickly, so you had said something before about Lindsay Halligan, just briefly. You said in her field, she's a very competent attorney.
I said she was considered to be a competent attorney. And, if you read public reporting about her career prior to coming to this position, there are people who will say that she was a very serious law student. She was very smart and accomplished. But in the same way, Joe, that I would stumble through a grand jury presentation, right?
Nobody's calling me and asking me to run the MIT physics department.
Or do brain surgery.
Or to do brain surgery.
Their loss.
But I will say, their loss, of course. But no, you're exactly right. I mean, that you can do what you can do. And again, this is one more example, Mika, of something we were talking about yesterday. Yeah. If you value blind loyalty over competence, this is what happens in Virginia. Yeah. This is what happens in the Texas case. This is what's going to happen when Judge Boasberg gets his second bite at the apple. It's this, Anne Applebaum wrote a book, Twilight of Democracy, talking about the key for people who want to be authoritarians is they value loyalty over competence. They get a lot of incompetent people around, and then they can run the government however they want. That may work in Hungary. That may work in Venezuela. Doesn't work in the United States of America. And it's important. Most of the defeats Donald Trump has faced this week, he's faced at the hands of Trump-appointed judges.
Ineptitude will get you that loyalty, but down the line there are consequences.